For that, the de facto advancement from his own funds, from his mother's fund, there is no denial to that fact. The accused never denied that he has taken certain money to build a gym, and the gym was built and the gym is run. Basically, due to some misconception, miscommunication regarding to the maybe to the security of his investment, de facto became apprehensive and started pressurizing the accused to return. But kindly appreciate once a huge amount is invested in a venture, overnight that cannot be taken. I have two options. Either I wait for the returns to come, or I break the partnership and say, I sell it to you, you take it. Instead of that, he started constantly pressurizing the accused to the extent that the accused was forced to go to the police, file a complaint. So we are not on that point, whether the police took cognizance of the complaint made by the accused and proceeded with that or not, but there was a complaint brought that is right. Subsequently, de facto comes up with a complaint which was registered under two sections of the Indian Penal Code, that is 420 and 406. Well, initially there is a paradox. Two cannot go together. One, Mr. Ganguly knowingly gives me the money. And the same way Mr. Ganguly cannot say that I was misled. 406 is where the person knowingly, consciously entrusts the money to the accused. And 420, you are not very well know that I was given a misinterpretation or impression that was not. No matter in any view of the matter, if even we take 406 separately, it does not stand because the money was not misappropriated or converted into the name of the accused. The gymnasium is there, that's the accurate fact.
এখানে কাগজ কোথায় গেল? এখানে যে কাগজ ছিল দুটো ইস্যু করে দিয়েছে। ও তো সাবমিশনটা নোট করা ছিল ওতে। ইয়েস পেয়েছি ঠিক আছে। Yes, Mr. Yes.
The 406 does not hold water because money was not misappropriated. It is the de facto component admits that there is a dip. 420, there was no misinterpretation that had there been a case that the money was taken to build the gym and land was purchased in the name of the accused, that is also not the case. Now, in the meantime, lot of waters flowed through Tista, Mananda, Tosha, whatever river we have in North Bengal. I was a very energetic gentleman. He went to raid the house of the accused to arrest the accused, and he came back arresting a motorcycle. My lord, I think the order is annexed. The Ridge Court took good notice of it, and he was brought back to his senses. The motorcycle was reparted with the accused. Till now, no 41 notice was sent in WhatsApp in a post dated.
Why WhatsApp?
I don't know. Lordship, I will reply. Why WhatsApp, and that too a date when we received it. The date was given something very. Nobody can comply with that.
Electronic means it.
Okay. So what happened after 8th September when the order was passed by this court that he will cooperate? They say that you are not cooperating.
Accused when? Accused when? He was not entertained. We wrote a letter. The accused can go physically police station, and if the officer is not available, he cannot attend. That is not my lord accused fault. But on 18/9, he had visited the.
What was the total amount of loan that was advanced by the complainant to the
1 crore 50 lakhs.
1.5 crore?
1.44.
But may I
Sure.
read the written representation to the IC Kotoval?
It's not dispute.
Yes. It is written, Ami Raja Mondal, Pita
Actually, page 5 of the
supplementary agreement.
Yes.
গত 15/9/2025 ডিমান্ড কার্ডটি স্যার আমার মোবাইলে একটা নোটিশ পাঠিয়েছে, আমি তা দেখে গত 15/9/25 ধীমান স্যারকে ফোন করি, উনি 17/9/25 12 PM আসতে বলে, আমি বাবাকে নিয়ে যাই, কথা বলি, উনি 18/9/2025 কমপ্লেইন নোটিশটা নিয়ে যেতে বলেন। 18/9/2025 তারিখে থানায় যাই, আয়োর সাথে দেখা করি, আয়ো এখন আমাকে কমপ্লেইন নোটিশ দিচ্ছে না, দয়া করে স্যার আপনি একটু দেখুন।
Father is also a signatory to the agreement.
No agreement. No, there's no agreement. No written document.
Other accompanying.
Father was just accompanying him and the transaction was done on oral basis. There is no document.
Where was the document?
But we do not deny the rent.
Okay. And that was given for this construction of the gym.
And in a partnership. The facto and the accused, they are partners to the
Oral partnership.
oral part. Oral transaction, oral partnership. But we are not denying that.
Okay. The complainant also does not dispute the fact.
Complainant does not dispute neither the transaction nor the partner.
Okay. Yes. You are for?
I am for the de facto, my lord.
My lord, hard defect to first.
Yes. Anyone?
My
You
lord,
can also submit.
Lordship, may I also start that they are required the defect will assist Lordships. First of all, Lordships, I'll invite your Lordships. First, they have taken a plea that the dispute between the parties and relation. There is no settled rule that the relation, there is no scope of cheating or others. Lordships, and the matter is taken up for your Lordship regarding the bail. And my senior learned friend submit that the 406 will not rank 420 together. This is not a case of criminal revision, your Lordships. This is a very initial stage of the investigations. Lordship, charge sheet yet not been filed. Amount is more than crores, whatever the 150 and 144. They cannot deny your Lordships as because your Lordship, there is a transaction and entire transactions, the statements of accounts collected by the IO. Here, your Lordship, they have taken a plea that they had been to the arrest the petitioner and subsequently not found, and the motorcycle recovered, and subsequently deed has been. We are not going for the dispute, Lordships. What is the case, your Lordships? This is the case. They took a one protective order not to take any coercive measure. Taking that order, your Lordships, now they are playing with the investigations officer. Though they had been to the police, but they intentionally did not meet the IO. In this case, IO is present and IO informed me that they are intentionally, and not only that, your Lordships, they said, I have got the protective order, so I will not meet, I will meet at the your Lordships. Kindly see the, and earlier occasion they have filed two reports, your Lordships, and unfortunately they hurriedly sent it, but after getting protective order, that is on your Lordships 8/9/25, and thereafter issued a 41. He had been to the several time of the accused, but no one to cooperate and not take. And ultimately, by way of the message, they have sent it. But it is revealed, and they have submitted that they had been to the several time, but I have not refused to meet. Actually, it is not a fact, your Lordships. They are trying to pay with the investigation officer after getting this order not to take any coercive measure, your Lordships.
Yeah.
So amount is huge, Lordships. Custodial interest are very much required, Lordships. So my humble submissions.
My lord, first of all, my lord, there is a written instrument. A deed was executed, my lord, between the, my lord, the petitioner, accused person, and my lord, the complainant. My lord, may I be permitted, my lord, to hand over, my lord,
What, Mr.
in this
Mojumdar?
form, my lord.
There is CD,
Let me go through it.
Lordship, there is a CD. CD also reflect the transaction and the accused took the money. That's why they denied also.
Sorry. Hello. देखे.
More better.
More better, it's
More better. It is a partnership.
This is not a more better as because lordship. So,
Lordship knows
We are
better
not
than me,
concerned.
with the permission of my
Please,
senior.
please.
Lordship knows that if a person invests in a partnership business, then he becomes the by
Owner.
virtue of by virtue of deposition of the money, he becomes part and parcel of the partnership. Unless and until the amount is misappropriated in the name of the another partner,
yes.
and it remains in the name of the partnership, or any form, any
Okay,
construction.
Mr. Give the copy of that.
It's a matter of.
So he cannot matter.
The only,
Madam, let Mr. finish.
yes,
Yes. My lord,
by dint of this agreement, the 1,44,000, 44 lakhs were.
my lord, 70 lakhs has been, my lord, paid, my lord, through online transaction. My lord, I want to, my lord, ponder upon, my lord, the charges under section, my lord, 316, 318. My lord, if your lordship kindly have a look, my lord, the proviso of 316, my lord, for a second, my lord.
BNS.
BNS, my lord. That is, my lord, breach of trust.
IPC.
This is under IPC.
No, yes. Huh? 316 देखला हूँ।
DNS. No, no, BNS.
Yes, my lord. My lord, 316, my lord, your lordship got it, my lord?
Yes.
My lord, whoever being in any manner entrusted with property or with any domain over property dishonestly misappropriates or convert to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mood in which such trust is to be discharged or in any legal contract. Here is, my lord, the contract, express or implied, which he has made touching the discharge of such trust or willfully suffers any other person so to do so, commits criminal breach of trust. Here, my lord, what happened? My lord, my client have been, my lord, induced to invest that amount from the very inception, my lord. On, my lord, mutual trust, on good faith, I, my lord, made the transaction in favor of the accused person being the petitioner herein. And thereafter, my lord, dishonestly, that amount has been misappropriated against me. My lord, that is the crux. So that is why, my lord, this provision has been attracted. My lord, so far, my lord, the criminal breach of trust and cheating cannot go hand in hand, my lord. That will be decided, my lord, in the course of while, my lord, the charge will be framed, not at this stage of hearing. This is a prima facie, my lord, investigation stage. I have been cheated, my lord. The online transaction is very clear, my lord. That has been, my lord, collected by the investigating officer. That is in the, my lord, the case diary, that the transaction has been made. So, my lord, breach of trust is there, my lord.
Initially investigation.
And thereafter, my lord, cheating.
Gym,
318.
this accused is carrying on the business of gym.
Yes.
Yes. My lord, on that pretext, my lord, the amount has been, my lord, taken over from me. I have been induced. And by virtue of this partnership deed, my lord, there is a legal contract. So breach of trust is there, my lord. And that amount has thereafter been deceived by the accused person.
That is not reflected at this stage. Investigation still pending.
An investigation is going on, my lord. He has been evading arrest, my lord, since long. My lord, on the contrary, my lord, though, my lord, the character assassination is not permitted, my lord, but this particular petitioner has previous criminal record on the self-same allegation, my lord. On the self-same allegation.
Okay.
He has a criminal record, my lord.
But law.
It will be decided.
Same
My lord,
thing
my
is
humble
submitted.
submission, my lord, at this stage, my lord, this prayer of anticipatory bail may be rejected, my lord. Otherwise, my lord, the entire investigation will be, my lord,
Maybe involved in
hampered.
others also. After investigation, the particular, it is also possible. So
But
as to
these are
at this stage,
far-fetched
if the investigation.
imagination.
By this manner.
But just
Learned.
my lord, there is a judgment of the
Advocate of,
court.
for the, learned senior advocate appearing for the petitioner submits that. Submits that. Which paragraph?
The issue 406 or 420 has been dealt at the bail stage by the court head bench.
By a division.
It's a very initial stage. It's not the stage. And there is a, so they may be.
And there are several
There are
other.
several other-
Investigations cannot be curtailed as.
And I have very well known
Senior
to
advocate
on WhatsApp.
appearing for the petitioner submits that by dint of an oral partnership by and between the parties, namely the complainant and the petitioner, comma, the complainant invested a sum of rupees, how much? 70 lakhs.
My lord, 70 lakhs initially was transacted.
70 lakhs at the initiation, totaling to Mr. Mujumdar 1,44,000. 1 crore 44 lakhs.
1 crore.
44 lakhs for running the gym. The allegations of misappropriation and cheating are mutually exclusive. The amount that has been transacted by the complainant to the accused is a result of a contractual obligation. The petitioner has all along tried to comply the order of this court passed on 8 September 2025. However, due to non-cooperation of the investigating agency, the petitioner could not meet the investigating officer, which will be evident from the letter addressed to the inspector in charge of which police station?
My lord, Kujbihar Kotwali.
Kotwali police station, annexed to the supplementary affidavit. The petitioner is ready and willing to cooperate in investigation. He seeks for grant of anticipatory bail in favor of the petitioner. To buttress his contention, he relies on a order of a coordinate bench passed in Pranab Shankar Sarkar, CRN within bracket A 320 of 2025. Learned advocate for the state opposing such prayer submits that the investigation is under progress. A huge sum of rupees 1 crore 44 lakhs are involved in the present case. The complainant was duped by the petitioner to part with such a huge sum. Further, the petitioner has not complied with the order of this court, though several attempts were made by the investigating agency to serve notice under section 35(3) of the BNSS. He seeks for dismissal of the prayer for anticipatory bail of the petitioner. Similarly, learned advocate for the de facto complainant submits that primarily the facts as revealing from the record shows of criminal breach of trust. An agreement was entered by and between the parties at the time of at the time together for sharing the profits on such basis. An amount of rupees 70 lakhs odd has been transferred to the account of the petitioner online. However, till date, no payment has been received by the complainant. He also seeks for dismissal of he files the copy of the agreement dated 30th April 2022. He also seeks for dismissal of the application. Here is the case diary and the materials on record. Admittedly, it appears that the amount that has been paid by the complainant to the accused is for running the business of gym. The deed of partnership as produced by the learned advocate for the de facto complainant shows that agreement has been entered for sharing the profits. Thus, the dispute by and between the parties arise out of contractual obligation. Learned advocate for the state has raised the issue of non-cooperation of the petitioner in the investigation. However, it will be appropriate to direct the petitioner to cooperate in investigation. Stop. In view of the above, I am inclined to grant anticipatory bail to the petitioner on condition to meet the investigating officer 43802 আছে ওটা থাকবে once in a fortnight until further orders, and also self join investigation and cooperate in investigation disposed of. A report over the report filed by the state is taken on record.
Anyone?
I can prove, Lordship, I am what petitioner of it. Lordship, this case was started by, started on the complaint of the de facto complainant under section 329 4, 115 2, 117 2, 118 1, 324 2, 76, 74, 3 subsection 5 of Bharatiya
What
Nyaya
is-
Sanhita, read with section 10 and 12 of protection of women, protection of children from sexual offences.
What is
The complaint is
117?
I can see.
I am appearing for the state, my lord. In last occasion, prosecution was directed to uh, produce a report regarding the agreement, the sale agreement produced by the petitioner.
Oh,
Now, this is the report.
now what is the fact of this case?
The LDPS case, Roshan.
Now, out of this, my lord, a vehicle cannot be changed the ownership through this agreement, my lord. That should be before the registering authority, my lord. Motor vehicles officer.
Sale agreement only power of attorney was given to one Bhupen Mundu. By the people.
He is the registered owner. Petitioner is the registered owner, my lord.
He has been seized from my
To
possession.
sign it. Oh. Learned advocate for the petitioner submits that nothing has been seized from the possession of the petitioner. The petitioner executed a general power of attorney in favor of one Bhupen Bormon for sale of the vehicle. Bhupen is accused.
No, my lord.
He seeks for anticipatory bail or grant of anticipatory bail in favor of the petitioner.
Now, charge sheet submitted against
Sorry.
4 accused persons.
A report filed by the state of Din is taken on record. Case diary.
Case diary is there.
Opposing such prayer for anticipatory bail, learned advocate for the state submits that the alleged contraband substance has been recovered from the vehicle registered in the name of the petitioner. What is the amount?
Not 181.750 kg of ganja.
181.
81.750. 181.
Caesar list at page number?
My lord, seizure list, page number 8 to 10. 8 onwards.
Mm, 180.910. No, 180.910. From the vehicle belonging to the petition. Registered in the name of the petitioner.
And the motor vehicle details are there, my lord, in the case diary, page 92 onwards, 92, 93 and 94. Regarding the ownership.
Question.
The commercial.
From the Bolero pickup. Bolero
Bolero
pickup
pickup van.
van. Bearing registration number
Hmm?
Bolero pickup van. Considering what is the registration number of this vehicle?
WB 78 6096.
73F 63 A 6393. लिख it up. बोला चाहिए 6396. 73F 6396. That's the other rejected.
Great, great.
Take this back.
Item 4.
None appears on behalf of the petitioner. Accordingly, CRM A 606 of 2020 and dismissed for non-prosecution. Your first state,
This is for deferral, my lord, no, not this.
non-prosecution. No restoration. They want to find.
I'm for the state,
Yes. Mr. Chakraborty, I will
my lord,
give you back that Mr. Jagriti Mishra moved an application
My
on
lord.
Friday.
my lord,
Some documents are in the record. I will return it to you.
my lord,
Okay?
yes.
As part of the case, I will not keep in the records.
My lord.
Yes. Next.
Item number 5.
Same. Who is for the state? Item 5. No, yes. Same order. आपको पता ना लगा मुझे दिन
Item 6.
My lord, I am for the state.
My lord, I am for the defect.
Advocate on record. One of the advocate's brother is hospitalized. That's why.
Service report? Yes. Service report filed by the state is taken on record. Hmm. Wednesday. On the prayer of learned advocate for the petitioner. Wednesday.
Great.
Mhm.
Item 7.
No, I didn't know what portrait.
Item service.
Okay.
Item 7, I am for the state matter. This is the service report.
Lordship, the my landed senior laying court number 1 and with pastor.
What is you move the application?
He's laying court number 1.
Ask him to put the password of 10 minutes password. Please don't. Next.
Item 8.
Lordship, item 8, yesterday, Friday, Lordship's taken up the matter. They have produced two documents, and basis of that document, they are tried to enter in the tender work. And subsequently, two tender work were verified by the IO, and it was found fake, your Lordships. So that was contested on earlier occasion. Mr. Hillol Poddar was appeared, and my lord give a further direction to file a fresh report. Lordships, I communicated the matter to the IC. IC personally send it, and the same report, the two fake documents they are produced to obtain trade license, Lordships.
Tender.
Yes, Lordship, tender.
Two CGMs produced by Abu Kaiser for order. Copies of those two have already been produced by the company with the IO video. Not issued by the here.
So, Lordships knows why they.
Where is Mr. Poddar?
Friday, yes, Hillol Poddar.
He has come today.
Hillol is.
It pass over.
Yes, sir. He is present, your Lordships. My lord.
It pass over.
Item 9. Well, I see again send the original through messenger.
Please.
Then 9, your lordship was speaking about your report.
This is under which provision?
Yes, Lord.
Which provisions?
Lord, 498A and 304B. Originally, my lord, there was 302 as well. But after filing the charge sheet, 302 was not passed. So only my lord 498A and 304B of the Indian Penal Code.
Okay.
Now, my lord,
The
I
bit-
happen to be the mother-in-law, the brother-in-law, and the wife of the brother-in-law.
Mother-in-law, brother-in-law. Who is
And-
mother-in-law? One.
Yes, Matrina Bishash.
Divas is the
Vivash is brother-in-law. And my lord, Tulika is wife of the brother. And my lord, the husband has been granted bail by the Garnet Trial Court. Case, my lord, is of 2020. And my lord, we have not been shown as absconding in the charge sheet. So, Lord, since the case is of 2020, your lordship was pleased to call for a report whether there is any Lord, proclamation for arrest.
Yeah, this is the report, Lordship. Report now.
Rina. Legal. Yes.
Lord, purely a case of suicide, my lord, the husband has been granted bail. My lord, we are after 5 years.
How many
Charge sheet
days?
was, yes, sir.
How many days he was in custody on anticipatory bail?
Anticipatory.
Where is that order? Where is that order granting anticipatory bail to the husband?
My lord, he was granted bail by the trial court. He was in
You are carrying that order?
No, I do not have.
Yes.
Yes, Lordship. Lordship, page number 4, 5, 6, Lordship, they are very one or two, was it your 4, 5, and 6?
Page number 4.
4.
Ujjwal is the husband.
Yes, sir. Ujjwal.
Page number 54, Lordship, PM report. Charge sheet কি হবে? Charge sheet?
Charge sheet, page 12.
কিসের আছে?
Is there any report with regard to incident which took place in the year 2017?
Report, Lordship.
There is an allegation that this
Page
the
number
accused
30.
persons tried to
Lordship, page number 34, 35 statement of the independent witness, Lordship.
no any injury or medical report. Which
Yes, Lordship, PM report, Lordship, 54,
Not
Lordship.
PM report of 2017. There is allegation of 2017.
Earlier, no, Lordship. No, earlier, no medical report, Lordship.
PM report page number.
Page number 54. Nature homicidal, Lordship. Within 4 years of marriage, Lordship.
The presumption of 3040 is there, but my lord, 302 has been struck out.
Seventy-four.
54, Lordship, 50.
Allow us to not face the trial. It's been 4 years.
আসুন। Independent witness page number?
And page number, independent witness, page number 34, 35. There, not this is.
The advocate for the petitioner submits that though the case was initiated under section 498A, 300, 4B plus 302 of the IPC. However, we'll stop. However, the charge sheet has been submitted under 498A, 304B of the IPC. The husband has been granted anticipatory bail.
No, regular bail.
Be granted bail by the Learned Sessions Judge. The petitioners are the mother-in-law, brother-in-law, and sister-in-law. There are no such specific allegations against the petitioners. He seeks for grant of anticipatory. Over a report filed by the state is taken on record. He seeks for anticipatory bolam. Offering such prayer for anticipatory bail and an advocate for the state submits that the victim died in the matrimonial home within 4 years of marriage. The PM report records that the possibility of homicide cannot be ruled out. He seeks for dismissal of the prayer for anticipatory bail. He reads the case diary and the materials on record. It is found from the statement of the witnesses that the allegations against the petitioners are general in nature. The petitioners, who happens to be the mother-in-law, brother-in-law, and sister-in-law, respectively, happens to be general in nature. Considering the aforesaid, PM records that the death was due to effects of hanging, which is antemortem in nature. The possibility of 54, the possibility of homicide cannot be ruled out. Be that as it may, charge sheet has been submitted under sections 490 304B IPC. Consider the above, I am inclined to enlarge the consider the above and keeping in mind the complicity, extent of complicity of the petition. Allowed. ঠিক আছে, just এটা করবে আর ওর জয়েন্ট ইনভেস্টিগেশনে কোঅপারেট উইথ ইনভেস্টিগেশন। চার্জশিট হয়ে গেছে যদি আর দরকার নেই, বুঝলেন? He'll attend the court on date fixed for appearance, এইটুকু দিয়ে বলি। একটা ফেরত দিয়ে দিন, দুটো একই কপি, একটা ফেরত দিয়ে দিন।
In this case, Lordship, before he submits, Lordship, there's a confusion. I think he has been hired by the de facto and he was appointed by Lordship, your Lordship.
Lordship, what I can request, just now I have got my appointment from the legal aid. Lordship can request, I am requesting Lordship to put it the matter tomorrow. I'll be ready with the matter. I have received the appointment by the de facto complaint.
So how these appointments are being made?
Legal aid, through legal aid, Lordship.
Through legal aid?
Lordship.
Without there being any application from the de facto
I
complainant?
think there is an application without the,
How
it
the
cannot
de
be
facto
happen.
complainant has made an application to the department as well as appointed an advocate?
Lordship, let us take out the confusion. What is the reason of? Let the matter come up tomorrow, kindly.
On the prayer.
I am for the de facto complainant.
Affidavit of service mechanism.
সেদিনই দেবে।
Dosh.
এটা item 10
10টা ওয়েডনেসডেতে রাখো।
Wednesday.
Date দিয়ে।
I'm grateful.
Day after tomorrow.
Grateful.
Confusion.
এটা কত? 10 নম্বর কোনো অর্ডার নয়, ডেটটা দিয়ে ওই দিনে পুট করে দাও Wednesday. You keep that with you. On Wednesday you place that.
Password আছে।
ও চলে গেছে জুনিয়র। ইনলোড করে দেখছিলাম, দেখে যাও এখন। এখন দেখে যাও না, একটু পরে। They will not come.
পাসওয়ার্ডই থাকলো।
This was for default or non-prosecution. Next time again they will take a plea that we were not there.
But without somebody moving the application, how can the court pass an order?
It's a prayer from the prosecution side. We are ready, we come. Problem is, my lord, if it is dismissed for default, be very honest, my lord, we cannot raise our bills about. We don't raise our bills, the matters of which are.
It is not dismissed for default, it is dismissed for non-prosecution.
Even then also. We are ready, we come here, but intentionally there.
Then I have to send persons from my court to ask the learned advocate to appear. If somebody is not moving the bail application, what can be done?
Matters were dismissed on merit, there are calls happening.
Show me one order. Show me one order.
But definitely,
Without the matter being moved by the learned advocate for the petitioner, it was
there was a matter.
dismissed.
Yeah, the prosecution showed this thing. I can say that. You can say about the petition.
Service upon the victim girl, my lord.
Yes.
I effected the service in law.
এইটা তো নেই।
For the statement.
Wait,
Already
Come
had
down.
it.
পারলে কতক্ষণ বেরোবে দেখি। নেক্সট 11টা করো।
Item 11.
I am for the state. So the area 35 grams of malod heroin malod was recovered from one person malod in steel bottle. But where is it? He was taken into custody malod page 12 malod if your lordship kindly have a look malod. Page 11.
What is your name?
Malod, my name is Vishnu Bhatt. Malod, this person was malod caught red-handed from his possession that intermediate quantity, my lord, was recovered. He has been granted bail by the learned court. From his
Ukil.
lordship.
Ukil.
Ukil Bhot. He was the person, he was, my lord, caught red-handed with the, my lord, intermediate quantity of contraband article. He has been granted bail. My lord, from his custodial interrogation, my name have been, my lord, recovered. Charge sheet has already been filed. He has been, my lord, granted bail.
Accordingly.
It's the intermediate quantity, my lord, 35 grams.
Vishnu.
My lord, season list is page 12.
Yes.
Lordship, to be fair, honest, actually, the quantity is intermediate. That's why under the charge is submitted under section 21B, which is less than commercial, but more than lesser small quantity. And the exclusive position is of Ukil Burman, and from the statement of the Ukil Burman, the name of this petitioner actually transpired as a seller of the heroin.
Now, the advocate for the petitioner submits that. Give the case diary. Case diary.
Yes.
Submits that. The name of the present petitioner is transferred from the statement of the co-accused. There are no such recovery from the exclusive possession of the petitioner. The person who was apprehended on the date of incident has been granted bail since the quantity was intermediate quantity. Upon completion of investigation, charge sheet has already been submitted. He seeks for grant of anticipated bail in favor of the petition. Learned advocate for the state. Submits that. Also submits that the name of this petitioner is transpired from the statement of the co-accused. Where is this statement?
Flapped. It has been flapped. Statement of Ukil Burman, stating Vishnu Burman is the seller from whom he procured.
Stating that the present petitioner is the seller from whom he has procured the contraband substances. He seeks for dismissal of the bail application. Anticipated bail. Here is the case materials on record. It is found that the name of the present petitioner is transferred from the statement of the co-accused. There is no such. During the course of investigation, there is no recovery from the possession of this petitioner.
One indulgence, state raised objection. One indulgence.
Opposing opore bole to opposing such prayer for bail. Stated ক্ষেত্রে কোনো সাবমিশনের আগে. In view of the above, I mean, going to extend the benefit of anticipated bail in favor of the petition.
Much obliged.
Allowed. Meet the investigating officer once in a fortnight. Join investigation.
Not to leave the jurisdiction of the
No.
NDPS court.
যদি সাপ্লিমেন্টারি কিছু হয়
For the petition, allegation under section 126(2)64 70 subsection 109 of the BNS Act, corresponding to 339 376D 307 of the Indian Penal Code. The allegation, the principal accused has already been arrested, subsequently granted bail. The petitioner name
Service.
Service upon the victim is complete, Lordship.
Lord, the medical report suggests that no injury report, no injury in the private, in her private part, Lord.
Service and 164 statement.
And Lord, statement of the co-accused also contradictory, Lord. Like kindly come to the co-accused already granted bail, Lord. Kindly come to page number 14. Of my petition.
126 is corresponding to which section?
126, 339,
And 109?
64.
Age?
Page number 14, Lord, of my petition, paragraph number 5, Lord. Paragraph number 5. The mayor is. Medical report particular one.
See.
160. He was arrested subsequently. This is anti-Semitic. एक लाइन बोलो, एक दो लाइन बोलते हुए।
Medical?
Medical is at page number 23 and 24.
There are two accused.
Yes.
Charge sheet has been submitted.
Charge sheet has been submitted, Lordship.
No part of the
Now the question here is, Lordship, the other person had been granted
bail.
bail, Lordship. He was arrested and subsequently granted bail, and Lordship has gone to the 164 statements. He lies on the similar footing. So that is the only question, Lordship.
Similar putting I am not paying, but I am trying to convince para number 5 of the earlier order.
Ashu,
And the medical report.
Learned advocate for the petitioner submits that there is contradiction in the FIR vis-a-vis the statement of the victim under section 164 of the CRPC. Co-accused have been granted bail by this court. He seeks for
No, one act is, back is. No, my, Jahidul is the one act is.
he's not the co-accused.
Yes.
Who accused?
One question.
Co-accused has been granted bail by this court. He seeks for upon completion of investigation, charge sheet has been submitted. He seeks for grant of anticipated bail in favor of the case. Opposing such prayer for you are for de facto complaint. Learned advocate for the state as well as the de facto complainant submits that there are implications of involvement of this petitioner in the alleged offence. They seek for dismissal of the prayer for anticipated. Here is the case there in the material. The victim in her statement indicates its petitioner of his involvement in the alleged offence.
Legal case, yeah.
Considering the above said and the nature and gravity of the offence, rejected.
One prayer, one commission will be recording. Medical report,
Medical report?
do not suggest the petition.
Not now.
Kindly, otherwise I kindly, think not I have not made submission. Kindly.
Medical report does not support the case of the prosecution.
I can talk in.
Actually, बोले दिन तो ये the victim alleges of such fact before the attending doctor. ঠিক আছে? না আমার family. Petitioner.
I'm paying for the next circuit.
Why? What is this case?
So it's medical treatment. It's not from.
Last time, Lordship, they are taking time, Lordship, adjournment of matter. From last week.
Last circuit you have not. Next circuit. None appears. Who is the filing advocate? Who is the advocate?
Ranjit Singh.
He's not coming to court.
Yes, last Friday.
Call him. Ask him to come. What is your name? It possible. Ask him to come.
Password.
Next.
I can I am for the state, your worship. 14 I am paying for 1 day accommodation, State is 80 It's
On 19th itself,
Yes,
you have
there.
taken time.
Yes, Malord.
Make your submission, whatever it is there.
Malord, in order to obtain, Malord, the copies of the order copy, bail order copy.
Whose bail
by
order?
the learned court, my lord.
One,
12 accused person, my lord.
How many?
12. In total 12, my lord. I have been, my lord, arrayed in serial number 6. My lord, most of the accused persons have been granted, my lord, bail by the learned trial court. My lord, I have to obtain, my lord, the order, my lord. Kindly give me 1 day accommodation.
What is your name?
My lord, Monu Sheikh.
Manushi. One report has been called for by the earlier order, my lord. The report is received by the.
No, there was no such order for filing report.
Yes, my lord.
What is
This is the report, my lord. Warrant is pending, my lord, not executed.
Okay.
Till
Warrant
today.
may be-
Warrant issued and that was not executed due
The
to
report filed by the state is taken
absconding of the
for the
present
advocate for the petitioner seeks accommodation. It is in the Wednesday thereafter. Day after tomorrow.
Lordship.
The report is kept to. I'm grateful to your lordship.
Or item 15 and 16 arising out of same PS case number.
Yes.
Both petition can be taken together, my lord.
My lord, this is that matter, my lord, in which, my lord, this legacy jewelry brand of Jalpaiguri,
Really?
Silver Queen Jewelers.
Hmm.
My lord, the complainant happens to be an advocate. Now, my lord, I'll straight away take your lordship to the
I beg to appear, my lords, for the complainant.
Hmm?
Lords, I beg to appear for the complainant, my lords.
Yes.
my lord, the petitioners before your lordships are, my lord, partners of these jewelry firms. Now, my lord, all the other partners have been granted bail by this honorable court. My lord, 2 have been granted bail, anticipatory bail by this honorable court. 2 have, my lord, voluntarily surrendered and, my lord, granted bail by the honored trial court. We are, my lord, on the same footing so far as the partnership is concerned. Because, my lord, the money was paid to the partnership firms.
15, 16 actually.
Now, my lord, written complaint, my lord, starts at page 9. Paragraph 2, my lord.
কত পেজ?
Yes.
So, my lord, it says leveraging this long-standing relationship and trust built over time, Mr. Sinhal and his family members, namely his wife Sarita Sinhal, Chetan Sinhal, son-in-law Amit Agarwal, and brothers Pawan Kumar Sinhal, Suresh Kumar Sinhal, Prem Kumar Sinhal, and Vijay Kumar Sinhal, lured us into investing in a so-called jewelry advance scheme. They floated this scheme as the best in the market and to compete with major jewelry brands operating in the market. Given their family's decades-old reputation in the jewelry business and multiple well-established stores in the city, there was no reason for us to suspect foul play or that we were being targeted in a carefully planned conspiracy to cheat and defraud us. In March 2023, during a routine visit to their store, Chandraprakash Sinha and his son, in the presence of his other family members who used to be in the store, induced us to invest our life savings in their scheme. They promised that we could purchase jewelry in the month of March 2025 at the prevailing rates at the time of advance payment, and that we would also earn 12% annual interest on the amount paid. We were assured that we could choose jewelry of our liking from any of their stores, and the scheme was presented as entirely trustworthy and backed by their family businesses. Now, about paragraph 4 at page 10. These
There
are
was
below
no
the amounts.
agreement.
Yes, my lord.
There was no agreement.
My lord, initially there was no agreement. However, my lord, the ledger accounts. There was.
Okay, you continue.
Yes.
There initially at the time of payment there was no agreement.
At the time, because my lord, what I'm coming to, my lord, is that this gold scheme that they are talking about, there was no such gold scheme. My lord, before this honorable court, twice in the anticipatory bill applications, before the learned trial court, the complainant was asked, my lord, if there is a jewelry gold scheme, there has to be at least one document, at least an invitation to offer, a pamphlet, an advertisement, a notice, something, my lord. There is no such thing as this gold jewelry scheme. What this amount is, my lord, an unsecured loan, which the complainant has paid to the, my lord, jewelry firm Silver Twin and Gold Diamond Silver Twin. These payments, my lord, were made. These are, my lord, the ledger accounts.
Miloj, I don't have what my friend is submitting, Miloj. This is not part of the application. Miloj, what he's submitting, Miloj, I don't have a benefit of those documents.
I'll come to that. Lord, we'll find the two amounts paid. First, my lord, I have submitted gold, diamond, silver coin jewelers ledger account.
Yes.
That, my lord, specifies the amount of 50 lakhs. The first, my lord, installment of 3,51,370 was paid. TDS was deducted, my lord. That is part of my application. There is an admission to that effect in the complaint as well. I had paid the first installment to them. After that, my lord, as I had submitted to your lordship the other day, my lord knows very well that after COVID, my lord, these gold prices have risen to an unprecedented extent. Now, my lord, large corporations like the, my lord, Tanishqs and the, my lord, Kalyans, they have benefited from this. And, my lord, relatively smaller jewelry firms like ours, they are, my lord, on the other side of the spectrum who have, my lord, lost humongous amounts of money. That is, my lord, the crux of this dispute. After paying the first installment, my lord, this business took a plunge. Both these firms, my lord, they ran into huge debts, and my lord, there was loss of inventory. There's no inventory left, rather, at this moment. My lord, we are in the process of selling out our properties and paying off the money lenders. My lord, this component also happens to be a money lender to us, who, my lord, put this money in our business for us to, my lord, operate that money as a working capital. That is, my lord, all that there is to this dispute. Completely, my lord, a civil dispute. Now, my lord, thereafter comes to my lord, page 24 of my application. Page 24, my lord, is the form 16A. Page 24. What is form? Yes. Page 24, my lord, is the form 16A. The payment of, my lord, 3,51,370, on which, my lord, 10% TDS of 35,137 was deducted from our account. The complainant has paid his income tax on this TDS amount. Now, my lord, thereafter takes page 27.
Now, what was agreed between the parties, even if it is orally,
Yes.
to share certain amount of profit of the business, or they will refund it? Madam?
These, how this works, my lord, we pool in money from, my lord, relatively, my lord, affluent customers, affluent, my lord, like the complainant. We pool in money from them. We, my lord, give them a certain interest for a particular period. Let's say, my lord, we take the money for a 4-year period. For 4 years, we will pay them the interest at the agreed amount, which in this case, my lord, was 12%. After the end of this 4 years, we pay back the amount entirely, the principal amount.
Okay,
That was
this
not the
3,51,000 odd.
Yes.
This is a part of that 12%.
Yes.
First amount that has
Yes.
been paid.
The first installment that happened
Okay.
at the end of the next financial year, that was paid.
Okay.
Page 27, my lord, is another payment of 1,05,000.
Yes.
1,05,000, my lord, 10,500 TDS paid on. And my lord has seen the ledger account. It says, my lord, interest on unsecured loan. I had submitted the ledger accounts, my lord.
Yes.
Kindly sees the entries, my lord, interest on unsecured. This was, my lord, essentially unsecured. An affluent person who has the, my lord, resources to pay us will pay us at the agreed amount. That is the arrangement that we enter into. After a relevant period of time, we return back the principal amount. That is how, my lord, general, relatively smaller size jewelry firms work. Because jewelry and gold, my lord, is such a volatile commodity. My lord, we need working capital to, my lord, replenish our resources and our inventories. And, my lord, in such circumstances, the complainant approached us, and he has, my lord, been in contact with us for last 30 odd years. He is an old customer of ours.
Oh.
There is no such thing as, my lord, fraud which has been committed. The amounts were paid to the, my lord, respective partnership firms. I am, my lord, on the same standing as the persons who have been granted bail, because they also happen to be the partners. My lord, they have been granted bail, and on the finding that there seems to be no, my lord, need for custodial interrogation at this point. I also, my lord, submit the same thing. My lord, lastly,
What is page 30? This memorandum of understanding?
my lord, a very peculiar, my lord, situation that we, my lord, in the month of July, I, my lord, being the counsel of my client, and also, my lord, the complainant happening to be from the same fraternity, I, my lord, approach the complainant personally that please do not pursue this case. Let us enter into a memorandum of understanding. We are ready to pay you. Let us come back. Let us start our businesses. Let us get the resources. Then only we can be able to pay. So kindly execute this memorandum of understanding and let us, my lord, stay away from the, my lord, because police is after us. Police is after us with all their resources. Now, my lord, to, my lord, get out of that situation, we ask the complainant that please enter into this memorandum of understanding. You also know that we have not committed any fraud. Kindly, this memorandum of understanding, my lord, thereafter. So, my lord, the terms at page 37.
The petitioner Sarita Singhal,
Yes, my lord.
she is the
She is the,
partner.
yes, she is one of the partners.
Partner of which company?
My
Mrs.
lord, Silver Twin Jewelers. Silver Twin Jewelers as well as, my lord, Gold Diamond Silver Twin Jewelers.
And Suresh Agarwal is the complainant.
Suresh Agarwal is the complainant.
Okay. That is all?
Yes, sir.
That is
Yes. No, my lord. Thereafter, page 39 onwards. 39 onwards are all the checks that we had executed and we had requested him for some time. We told him that we are ready to pay these checks to you, execute these checks in your favor. Give us a period of 5 months time. We will pay back the entire money. Let us come back because we're in the process of selling off our properties. Let us sell off our properties and pay back your loan. That is all we wanted from you. There is no foul play involved in this particular transaction. Lord, if there was any foul play, there was any intention to deceive, we would not have done this.
So this memorandum of understanding was not signed.
He did not, he refused to execute it. He refused to even accept these checks. Lord, kindly see the firms from which the checks are issued, my lord. Silver Twin Jewelers, page 39, page 40. Thereafter, my lord, page 41 onwards are Gold Diamond Silver Twin Jewelers. From the respective firms' accounts, we wanted to pay him back through these checks. Post-dated checks, we wanted a 5-month period. Give us 5 months. Let us arrange the amount. After that, my lord, we have not been able to come back because behind our back, this complaint was lodged. We went for our treatment, my lord. I had submitted the other day, my lord. Chandra Prakash Sinhal, my lord, he is a patient of, my lord, myasthenia gravis. That is, my lord, is an acute neurological disorder. Page 22 onwards, my lord, are the relevant documents. Page 21, my lord. I went for my treatment at Calcutta. 21, 22, 23. And my daughter, my lord, Anuja, she is, my lord, a patient of thalassemia. So our family, Chandra Prakash Sinhal, Sarita Sinhal, Chetan Sinhal, and Anuja Sinhal, we went to Calcutta for our respective treatments. For my Chandra Prakash's treatment and my lord Anuja's treatment. Behind our back, my lord, this complaint came to be lodged in the month of July. After that, my lord, we have been, my lord, not been able to come back. And this is what has happened.
Yes.
Please.
My lord, another thing, my lord, the defamation that we have, my lord, been subjected to. These are, my lord, broad, bold letter, my lord, news articles. My lord, kindly grant us bail. On any condition.
See. My lord, 161 statement of another victim is there, my lord, page 46. And page 100 is the defect 101, 46 and 100. BNS বের করতো 480 into 180. 480. Sorry, 380. 380. Hmm. 420, 406.
What is the total amount that has been paid?
85 lakhs.
85.
85 lakhs.
As per our accounts, my lord, currently about 70 lakhs standing. There is a dispute with regard to that.
Yes.
My lord, and my lord, partnership deed also, two partnership deeds are there, my lord, of the accused persons, my lord. Both are seized. My lord, page 23 onwards, 23 to 28, first one. And 37 to 42, second one. 23 onwards, my lord. Investigation still in progress, your lord.
No, the Sarita petitioner is the partner
One of the
which-
partner.
Huh?
One of the partner.
All are partners.
All are partners.
Sorry.
You know, all the accused persons are family members. Brother,
No,
wife.
this petitioner is not the partner of. One is Gold Diamond, another is Cinderella.
Yes, madam.
Silver Queen.
Silver.
Silver Queen, my lord?
Silver Queen, Pavan, Chandra, Prem, and Suresh are the partners.
Yes.
Yes.
And Sarita is the partner of
Of Gold Diamonds.
Gold Diamond.
Gold Diamond.
Yes.
This has been advanced to both the firms.
Yes.
Yes.
Both the parts. 50 lakhs to my lord Silver Queen and 35 lakhs to my lord Gold Diamond Silver Queen.
They, all the persons are relative, my lord. All the persons are relative.
Yes. Any other thing?
Investigation still in progress, your lordship.
Yes.
Milords, will I submit?
Yes.
Just one thing.
Milords, I am for the company. Milords, there are broadly,
One
Milords.
second, one second.
Yes.
Lord, a subsequent, Lord, fact has, Lord, evolved. Lord, there is another FIR pending, Lord, by one Radhesham Agarwal. In that FIR, my lord, the principal allegations are against my brothers, my lord, Pawan Sinhal, Prem Sinhal, and all of those. They have all been granted bail, my lord, in that FIR. That is, my lord, a subsequent FIR for 25 years. So, my lord, that, my lord, I have to bring to your lordship.
Milords, two things, Milords. What comes from the petitioners and Milords, as I understand, he says one, this is an unsecured loan advanced to the accused people.
Hmm.
And number two, that co-accused have been granted anticipatory bail by this honorable court. So therefore, your lordship should also consider. Milords, before coming on to the merits of the case, Milords, two very important things. One, Milords, like me, there are at least 3 other complainant, Milords, who allege the same thing, that a scheme was floated by them. And pursuant to that scheme, Milords, all the people deposit certain money, and the promise was that they will give an interest till the time scheme matures. And once the scheme matures, Milords, and that's the benefit, Milords, it's not the interest that the complainant was looking for or other people who are similarly placed, who have filed similar complaints, were looking for, Milords. The upside of this, Milords, was that whatever is the prevailing gold rate at the time when my scheme matures, I will get gold of that value. And Milords, my colleagues are standing, they will hand over, Milords, 1 FIR and 2 other complaints, Milords, filed by other people who've been lured in the same scheme. So, Milords, will kindly peruse that. That's one. Number two, Milords, the present applications, Milords, have been filed by a third party who's the daughter, Milords. And Milords, the reason I say this, Milords, is very important because your lordship will note section 482 of BNSS. There is a specific requirement, Milords, that in an anticipatory bail application, the applicant himself or herself should come before the honorable court. Milords, I asked the question as to why there is a requirement that the applicant himself should come. Milords, because one, the language of 482 requires that the applicant files the bail application himself and not through a third party. Number two, Milords, your lordship's court have passed various directions, including the Supreme Court, which says one, that you will have to declare your antecedent. Milords, no antecedents have been declared in this petition, Milords. And Milords, my friend will explain to your lordship as to what is the reason.
Milord, at the time of filing there was no antecedent.
No, please don't interrupt. I didn't interrupt when you were arguing. Milords, my friend will, Milords, address your lordship on why no antecedents have been declared, why these 3 similar complaints on similar schemes were not placed before your lordship. And Milords, if I may, Milords, in this context, just place one judgment, Milords, of the Honorable, Milords, Madras High Court. This is state. This is Ravi versus State, Milords. And Milords, there are similar judgments of other high courts also, which emphasize, Milords, it's a mandatory requirement that the anticipatory bail application, unlike a regular bail, should be filed by the applicant himself. Your lordship will kindly see 4.
Section 438.
Yes, Milords. It's a short 4-5 page order. Milords, if I may read with your permission. Paragraph 4. The provision says when any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense, he may apply to the High Court or the Court of Sessions for a direction under this section that in the event of such arrest, he shall be released on bail. The highlighted portion will clearly indicate that an application for anticipatory bail must be filed by the person who apprehends arrest on accusation of having committed a non-bailable offense. The provision cannot be compared with other provisions found in CRPC dealing with regular bail after arrest. Section 436 CRPC deals with the release of persons arrested of an accusation of having committed a bailable offense on bail. Section 437 CRPC deals with the powers of a court other than High Court or Sessions Court to release a person arrested on accusation of or suspected of commission of a non-bailable offense. Section 439 deals with the powers of the High Court and the Court of Sessions to direct the release of the person accused of any offense and is in custody. None of the above said provision contemplates an application being filed by the person arrested for a direction for his release on bail. Those provisions simply deal with the power of courts and the condition that can be imposed while directing the release of the person arrested. Now, Milords, it's very important, Milords, and there is a reason why, Milords, courts emphasize in case of an anticipatory bail, especially the person himself should come. And Milords, the reason is simple that there are several disclosures, several undertakings, Milords, a person is required to give to the Honorable Court. And Milords, that can only be given by the applicant himself, Milords. It can't be tomorrow, Milords, that a third party comes and files an affidavit saying that I am giving an affidavit that the applicant has not approached any other court, that the applicant has not committed any other crime, that the applicant will abide by the conditions that the court passes. So, Milords, on this point itself, Milords, the application should be rejected, Milords, but I am not restricting my submission on the maintainability, but your Lordship may kindly consider this point. There is another judgment of Milords Madras High Court. Similarly, Milords, on the same line, my colleague will pass over. I am not troubling your Lordship. This is, Kerala High Court, State of Kerala versus Vishnu, para 31. Your Lordship will just take a note of that. Milords, then the next point, and Milords, it's very interesting what my learned friend says, Milords, is that... Yes,
Wait,
Milords.
wait.
I'm sorry, Milords. Para 31, Milords, of this Kerala High Court judgment. Similar lines.
Yes.
Yes. Milords, now, Milords, the next point, Milords, which has been urged is that this is a simple unsecured loan given by the complainant to the accused persons. And therefore, it's a pure civil transaction. Milords, 2 or 3 broad responses on that, Milords. First, Milords, if I were to accept what the petitioner is saying on the face value, Milords, then the question begs as to why there are other complainants who have filed a similar complaint on the similar scheme against these people. And your Lordship knows how the jewelry business typically works, Milords. This is a business of trust, Milords, that people have trust in their jeweler. And Milords, I have said so in my complaint that I have been dealing with this jeweler for last 50 years. So, Milords, if my jeweler gives me a scheme saying that, if you have some money, you invest in this scheme, after 2 years, the scheme will mature. And then whatever is the prevailing gold rate, you will get the same weightage of whatever you paid at the time of deposit. That's one. Milords, number 2, Milords, your Lordship knows there is a specific legislation in the state of West Bengal, which is Bengal Money Lenders Act. So, Milords, it can't be so that anyone tomorrow can get up and start and get into the business of money lending. Milords, that legislation specifically prohibits the giving or receiving of money in loan except from the person who has, Milords, a license for money lending. So, Milords, it's very convenient today, Milords, to simply twist it to say that this is a simple case of money lending. There is no scheme involved. And what is also interesting is that I am only paying interest, and that is why people are coming and depositing their money with me instead of a bank or a financial institution. Milords, what incentive do I have to simply give money on interest, Milords? I would rather, Milords, go and give it to the bank or some other, Milords, financial institution.
Why did you give the money then?
Milords, because, Milords, the accused people, Milords, are running a jewelry shop in Siliguri for last 50 years. I have been regularly buying jewelry. Milords, one fine day they float a scheme. It seems to be a lucrative scheme. Milords, I gave the money. And Milords, with the hope, with the trust that they will return back. And your Lordship will note there are 3 other complainants, Milords, standing in the same line. And what I know, Milords, from other sources, news reports, is that there are multiple such people. So it's not a case of one-off, Milords, a transaction that has been done. Milords, on the last point, Milords.
It was oral. This scheme was oral.
Everything is oral, Milords. The only payment was through bank transaction, Milords. No cash payment, Milords. I gave it through bank. And Milords, all I have gotten till date is one, Milords, installment of interest, because this scheme was to mature in 2 years. So first year I got interest. Second year, Milords, when I went back to say that now the scheme has matured, you please give me gold. Milords, what I find is their shops are locked. They have ran away, Milords. And Milords, one last thing, Milords, I must address, Milords, what my friend says, that because this is a partnership, all the partners sail and swim together. Milords, no doubt about the proposition of law. But your Lordship must kindly see what, Milords, the brothers of the accused person, because Milords, Chandra Prakash Sinhal, Milords, who's before your Lordship, and the family before your Lordship is the prime suspect, prime accused in this whole thing. Milords, my colleague Milords there will just hand over the bail application that was filed by the brother Pawan Kumar Sinhal, Milords, before this honorable court. Milords, kindly sees two paragraphs there. Milords, this is the anticipatory bail application filed by the brother. Your Lordship will take para 6 first. Your Lordship has that?
Yes.
6. If I may read out with your Lordship's permission. The petitioners respectfully submit that they are the brothers of Chandra Prakash Sinhal, whose Milords an applicant before you today. Around 42 years ago, Chandra Prakash Sinhal started a partnership business with the petitioners and their other brothers named Silver Queen Jewelers. Subsequently, in due course of time, from and around the year 2001, the accused number 1 began operating the business single-handedly. The petitioners also got separated and started their own business and further never interfered with and or were involved in the partnership business even though it was never formally dissolved. The petitioners severally asked Chandra Prakash Sinhal to remove their name from the said business, but Chandra Prakash Sinhal never allowed them to exit, as the same was their late father's wish that all brothers remain present in one business. For the said reason, the petitioners were in the name of partner in the said business, but they never interfered with any transaction, nor ever had taken any benefit, profit, and or have incurred any losses which the said partnership business might have incurred. Consequently, the petitioners have no knowledge. Now, Milords will see para 8, Milords. Milords, and the timing, Milords, is a suspect. It's quite unique, Milords. When my scheme is about to mature, it is at that time there is some medical emergency. The entire family leaves the city, closes the shop. Milords will see para 8, please. The petitioners submit that the petitioners only came to know regarding the said illegal fraudulent activity of the accused number 1 and his other family members on the day the notice dated so and so under section so and so, which was served to the petitioners pertaining to the instant FIR. And subsequently, Milords, this is important, the petitioners immediately tried to contact with Chandra Prakash Sinhal and his family members, being the accused number 2 wife and accused number 3 son. Milords, these are the 3 applicants before your Lordship today. But they found out that the flat residence of Chandra Prakash Sinhal to be locked and phone numbers switched off, Milords. Milords, even if, Milords, your Lordship were to believe that there was in fact some actual medical emergency, Milords, their conduct, Milords, demonstrates, Milords, it's writ large. What they did is, Milords, all of a sudden, they locked their shops, they locked their houses, and Milords fled out of the town. We tried, Milords, contacting through phone, through other people, not reachable, no response. And Milords, this is what even the family members are saying, Milords. So, Milords, what really happened is that, Milords, they, Milords, became greedy. They understood that I have to now repay back because of the change in gold market, etc. So better to either run away. And Milords, what they did after that, Milords, compounds the offense, which is this, Milords, memorandum of understanding. Your Lordship will see, Milords, kindly if I may just draw your attention once again to the MOU. Milords will come to page 32 first. Milords,
You are carrying the bail order of Pawan Kumar Singhal?
Yes, sir.
Bail order of Pawan Kumar Singhal?
Yes.
Yes, and Milords will see the reason there also. The only reason is that since they complied with the 41A notice, so therefore they are granted. And obviously, Milords, on the submissions, Milord, I showed to your Lordship, that was the submission made before the court, that Chandra Prakash Sinhal is the prime suspect and he controls the business.
Yes.
Lord, what my
Milords, I am not finished. Just, Milords, two more minutes, Milords. I'm grateful for your Lordship's indulgence. Your Lordship will see page 32.
Page 32
of the Milord's petition. Milords, any petition your Lordship may take, it's the same page number.
Yes.
Milords, there is no date given. It simply says in the month of July, which is, Milords, after Milords FIR is registered. And Milords, perhaps the police may have contacted them. Milords, this draft is prepared. I am seeing this draft for the first time, Milords, by way of their application. And Milords will then come, Milords, to this paragraph, which is, Milords, at page 34. Last paragraph. Milords, this shows, Milords, how the dealings are done, Milords, by the petitioners. Milords will see the last recital there. Whereas the first party hereof acknowledges payment of 3 lakh only in cash. Milords, I have made transaction through banking channels, and Milords, they expect that I will receive the money back in cash, and that too, Milords, your Lordship is aware, recently the Supreme Court has passed a judgment saying that any transaction above 2 lakh in cash must be reported to the IT department, Milords. Milords, I'm not carrying that judgment, Milords. My request is also that, Milords, given, Milords, they are admitting that something like this is done, Milords, there needs to be an investigation pursuant to what the Supreme Court has said, Milords. There is a clear direction. And Milords will then last see the checks. Milords, interestingly, Milords, my friend says that I have told them that I will repay back in few months' time. There is no date given in the checks. These are, Milords, all unilateral documents that they have prepared and brought before your Lordship to show as if there is some intent to settle, Milords. But my respectful submission, Milords, one, I am not aware of any meeting, any of these documents. I am seeing this for the first time. Number two, Milords, there is a clear admission that the money has been paid to them. And number three, Milords, even before your Lordship, Milords, there is no commitment as to when the payment will be made, how the payment will be made. These are just blank checks without any date. And Milords, just one last submission is, Milords, your Lordship is of course aware, Milords, I want to place one last judgment, which is Jagdev Prasad versus State of Bihar. Milords, this is a recent Supreme Court judgment, and your Lordship knows the issue on the concurrent jurisdiction. Whether your Lordship in the first instance should entertain an anticipatory bail application or the applicant should be sent to the Sessions Court. Your Lordship will kindly take this, Milords, very recent judgment of September 2025. Milords, para 6. Milords, this is by His Lordship Vikram Nath, Justice Vikram Nath and Justice Sandeep Mehta, para 6. And Milords, a case on anticipatory bail, where, Milords, now, of course, this issue is pending before a larger bench, but, Milords, there is still a direction to the Honorable High Court, Milords, para 6, if I may read. However, before parting, we do wish to express our sincere concern with the haste at which the High Court has dealt with this matter. While the scheme of CRPC, now BNSS, provides concurrent jurisdiction to the High Court and Sessions Court for entertaining applications for anticipatory bail, this court has time and again observed that High Court should always encourage exhausting an alternate concurrent remedy before directly interfering itself. This approach balances the interest of all stakeholders, first by giving the aggrieved party a round of challenge before the High Court. Second, this approach provides the High Court an opportunity to assess the judicial perspective so applied by the Sessions Court in concurrent jurisdiction instead of independently applying its mind for the first go. Further, the High Court fails to record any reason for directly granting anticipatory bail without impleading the appellant complainant as a party. Milords, of course, Milords, I am not, Milords, for a moment contesting your Lordship's jurisdiction in that sense, Milords, but, Milords, there is a change in, Milords, how the Supreme Court is now looking at anticipatory bail jurisprudence.
But then there is a judgment of Gurbakh Singh, I suppose, that it says that it is a concurrent jurisdiction, the party can approach any of the forum.
Yes, Milords. Milords, that, Milords, I am not doubting, Milords, but of late, Milords, what has happened, and this is a September 25 judgment, where, Milords, Supreme Court are saying, Milords, at least there should be an averment in the application as to what special circumstance necessitates the applicant to come before the High Court. Your Lordship will see the application. The application has nothing on why High Court directly. So, Milords, this is only for your Lordship's consideration, Milords. I am deeply obliged for the patient hearing.
Lord, if I may reply shortly. Firstly, my Lord, the first point that my learned friend came up with is that the petitioners have to come personally in a anticipatory bail application, which is, my Lord, differentiated from a regular bail application. Lord, may kindly see the provision itself. Provision, my Lord, 482. It says, where any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offence, he may apply to the High Court or the Court of Session for a direction under this section, and that court may, if it thinks fit, direct, in the event of such arrest, he shall be released on bail. Now, my Lord, this section itself is direct. It says, my Lord, may. It uses the words may. Now, my lord, if a person comes before the honorable court, our lord, I can show your lordship, my lord, hundreds of applications filed before our honorable court, in which, my lord, the family members are, my lord, the persons affirming the affidavits. Now, my lord, my learned friend has shown, my lord, judgment of the Honorable Kerala High Court as well as the Madras High Court, but my lord, none has been shown as to whether our Honorable High Court exercises such jurisdiction in such, my lord, constricted manner or not. In our Honorable High Court, my lord, the family members are entitled to file and affirm the affidavits of anticipatory bail application.
Show any judgment?
So, my lord, I'm stating the, my lord, our Honorable High Court's view on this particular stuff. My lord, if my lord clarifies your lordship's, my lord, your lordship's view, my lord, your lordship will find hundreds of applications filed in the anticipatory bail, my lord, jurisprudence, filed by the, my lord, family members. I am the daughter of, my lord, the applicants. The first applicant, my lord, Chandra Prakash Sinhal. I am the daughter of Chandra Prakash. I am the brother of Chetan and, my lord, daughter of Sarita. I have nothing to say which is different from what, my lord, Chandra Prakash Sinhal or, my lord, Sarita Sinhal's submissions would be. I am only affirming the affidavit on their behalf. There is no, my lord, prohibition to that effect, and the, my lord, our honorable court's, my lord, view in that regard.
No, you come up with the judgments.
Lord, judgments, my lord, because this
You have to,
point
if the
is-
Calcutta High Court has not passed any such judgment with regard to the proposition he has raised,
yes, my lord.
then one has to decide that whether the particular petitioner
Yes.
has to file an application and affirm before the court, because the
Yes.
conditions which are imposed in 438 is to be followed by the applicant.
Yes, true.
Followed by the applicant means the accused,
Yes, yes.
not the person who is affirming the affidavit. So his question is, he may apply, to my mind is, he may choose to apply and file an application for 438. The choice of filing of affidavit is not there.
It's not.
The choice of filing an application under 438.
Yes.
He may apply means, he may apply an application under 438.
Yes.
So if you can show any order of this court
Yes.
that yes, a third party can affirm an affidavit at the time of filing of 438, then we can decide this proposition.
My lord,
If it is not there, then we have to follow what is in the act.
to my knowledge, my lord, because the act does not talk about affirmation of the affidavit, neither does the
Then we'll
CRPC
decide this.
or, my lord, the BNSS specifies any particular
He may,
provision
no?
which, my lord, talks about affirming the affidavits.
Hmm.
Affidavit, my lord, is an affirmation which has to be seen by the learned officer, my lord, affirming, my lord, seeing the affirmation, and, my lord, clearing his conscience with regard to the execution of the act. That is all that is there to the affidavit. If Anuja Singhal today comes and states that no other anticipatory bail application is filed on behalf of Chetan Sinhal, Sarita Sinhal, or Chandra Prakash Sinhal in any other court, that my lord, statement has to be tested on its own merit. And if it is found false later, then, my lord, all of these persons will face the consequences.
No.
That is
What he is submitting, if that be so,
Yes,
then
sir.
in the provision itself, it could have stated that he may apply through his authorized agent, personally or through his authorized agent. That has not been stated in 438. That is his submission.
I beg to differ, my lord, on that point. That if
Then you
if
show,
the
you can differ
provision
many
does
things,
not-
but you show the proposition.
If the provision, my lord, does not expand itself, my lord, then it has to be, my lord, looked at liberally.
Okay, that is
If
your
my lord is
sub-
of the view, my lord, that this application is not maintainable on that point, my lord,
Yes.
my lord may reject on the ground of maintainability. But, my lord, the merits may be kept open, my lord, I'll come up with a fresh application filed by, my lord, the petitioners themselves. Because he's striking at the very root, and if your lordship is of the view that the affidavits have been affirmed wrongly, then, my lord, I'll come up with a fresh application.
I have not given any view.
No, my lord, I'm just,
If I
Because-
am to deal with all the aspects which has been argued,
then, my lord, let
he
me-
will help you.
Let me, my lord, come back tomorrow, Mr.
Day after tomorrow.
Yes.
Mr. Swenson, advocate for the petition. Learned advocate, Mr. Swenson, appearing through virtual mode also. Appearing for the de facto complainant also makes his submissions. Learned advocate for the petitioner seeks accommodation to make his further submissions. What you do is compile all this and place it on record. Learned advocate for the
May I also
petitioner
just
files
submit your judgment?
files What judgments?
Lord, on the fact, Lord, and as well as the Lord, the maintainability of this application. I
Now,
also,
again, if you come up with the judgments, what prevented you to file those judgments at the earlier?
Lord, just 3 judgments. I'll come up with 3.
This will make this. Again, he will
Yes.
ask for replying on those judgments.
In fact, I had, Lord, prepared the compendium, may I file it today. I'll address my submissions on the next day on this complaint.
Then you give a copy to him.
Yes, sir.
Give a copy to the de facto complainant as well as state. Let them go through the judgments, how this proposition is relevant, make their submissions.
Yes.
Correct, sir?
Grateful, my lords. Yes, my lords. Grateful. My
Compile.
lords, I will also, my lords, place one. My lords, may I just take your leave, my lords, to place one another that Supreme Court judgment on cash transaction, my lords, where he's averring that there's 3 lakh rupees paid, my lords, that needs to be investigated. There's a duty on the court, my lords, now.
Lord, that was paid throughout the period of, Lord, 3 years. We only asked him to acknowledge that. It was not paid in, Lord.
No. Now, my lords,
Which is
your lordship,
why, Lord, on the
I
earlier
think he's.
I had stated that there is a dispute with regard to the, Lord, liability. It is not, Lord, 85 lakhs as they say.
Please don't
It is around
extend your submissions now. It will go on like this. For you also. We are stuck in only one point, whether the application is maintainable by, if a affidavit is filed by a third party.
Lord, then
Please,
he went on to expand his submissions on the, Lord.
He is not expanding, you are expanding, you're filing the compilation. Why haven't you filed that compilation prior to that and given a copy to the other side?
No, Lord, my compilation was on merits, not on the point of maintenance.
Whatever, you never refer to the judgments at the time of hearing. Then?
Lord, takes it up on Thursday.
It's not on Thursday, on Wednesday. Yeah. On the prayer
Grateful.
advocate for the petitioner list. Which are the matters this is appearing as? 15 and 16. 15 and 16. দুটো আলাদা আলাদা অর্ডার করবে না? হ্যাঁ। কোনটা? ওটা ওরা কম্পাইল করে একটা দেবে। এটা তো ওদেরই জাজমেন্ট। এটা থাকবে। এগুলো থাক, এটা প্রিভিয়াস অর্ডার, ওটা রেখে দাও, এমনি রেখে দাও, কম্পাইল করতে হবে না, আমি নোট করে দেবো। ঠিক আছে, কম্পাইল দিতে হবে না, ওটা রেখে দেবে, আমি নোট করে দেবো অর্ডারে। হ্যাঁ, on Wednesday.
Grateful, my lord.
আমি
না দেবে না করে দেবে
Item number 8. Earlier, first product, you have to balance the first product, so সম্পদ প্রথম জলবতী and another product, I am only contacting Android and starting. When Anisur Rahman I am being person make it only 1 day accommodation because your losses, they will come, they will it's better.
Day after tomorrow. কালকে পারবে না, দিয়ে আসবে। Day after tomorrow, on the prayer or an advocate for the petition. এটা দিয়ে দিন। Who is for the state? On the prayer of learned advocate for the petition, this is matter on Wednesday.
এটা কি শেষ দিয়ে দিচ্ছি ওটা
দেখো তো আর কোনো খাস খবর আছে কিনা? 13টা লাগুন তো।
Next. Item number 13.
None appears on behalf of the petitioner, nor any accommodation has been sought for. In view of the above, the application being CRM A687 of 2025. ওহো এটা তো পাসও নিয়ে গেছে না জুনিয়র একজন
বিষয়টা ছিল তখন ফার্স্টে
State is there.
সেটি গেল কোথায় গো? রাখো রাখো পরে রাখো
If it is
আমার
ডিফিকাল্টি হয়ে যাচ্ছে এদিকে পাসও করে রাখো না সেকেন্ড হাফে একবার ডাকবো না এলে তখন
Item 17.
Yes, I am other state membership. আসে তো এখনই ছিল Scalp cutting.
দেখো পাসও করে গেল দেখি দিন yes
Person is there, my lord.
at least keep some of your juniors in court so that he can respond and call you you cannot wait like this
এটা একদম ঠিক
yes how many accused are there
My lord, two accused person, Nawab Hussain and Abul Mia. Abul Mia, the second FIM accused person, the petitioner before your option. My lord, kindly turn to the next page, page 9. My lord, that principal accused, that is FIM accused person number 1, but he has been, my lord, granted an executive with the learning sessions. My lord,
your application was rejected
yes. Yes, page 7.
what are the sections
126, 115, 117, 109, 1, and 3 of the BAS. But the gist of the allegation is that the lot of two, the lot of e-rickshaw puller, that is not what e-rickshaw puller, they were in a fight, they the complainant want to take over him, and out of that altercation, this allegation has been after lodged.
yes
They were in a free fight and thereafter.
I have folded one page, page 17. Scalp cut injury is there. Charge sheet submitted, Miller. Only scalp cut injury. Just like this. Nothing mentioned in simple or grievous.
and the injury report is there
Only page 7, Miller. And page 19, discharge summary is there.
where is the statement of the injured
The statement of the victim, Miller, page. Elder brother of the victim is there, Miller.
page 7
Page 9, Miller. Page 7 and 8, neighbor.
Page 8 neighbor, 9 হচ্ছে brother of the victim.
7 and 8 দুইটা আছে 7 and 8. Elder brother of the victim statement is there at page 9. 161. The company is the wife of the victim.
The narrative, the inquiry is concerned. Principal allegation lies below, it is the accused number one, if I name accused person number one. He has been below in that stuff. Is that legal?
Learned advocate for the petitioner submits that out of pre-fight, the victim sustained injuries and has been discharged after 1 day. The co-accused have been granted bail, anticipatory bail, by the learned sessions judge. He seeks for a grant of anticipatory bail in favor of the petitioner. Opposing such prayer for bail, learned advocate for the state submits that there are specific allegations against this petitioner of assaulting the victim, resulting in scalp injury. He seeks for dismissal of the application. আর উপরে বলে দিন ওনার সাবমিশনে চার্জশিট has already been submitted. There is a case and materials on record. It appears that the victim was assaulted on the date of incident. By both the accused persons. One of the co-accused have been granted bail, anticipated by the sessions judge. The victim sustained scalp cut injury and has been discharged after 1 day. After completion, a charge sheet has been submitted. In view of the above, I'm inclined to extend the benefit of anticipatory bail in favor of the petitioner. Accordingly, allowed.
I am grateful, dear Lordship.
কত নম্বর হলো?
I am grateful, dear Lordship.
Yes, thank you. Next.
Or I am for the defective complaint.
State remain present with the original from date field.
In this case,
Nice brothers. ঠিক আছে?
the petitioner on 24th of September by the coordinate bench, and this petitioner is all the other accused persons are on bail and on the paying for bail, the ground of parity, any stringent condition they kindly granted.
My lord. My lord, the present petitioner is the mastermind of this case. The present petitioner, my lord, make a fictitious document, fictitious Aadhaar card in the name of Mahesh Prasad. And my lord cheated 3 persons, including the present complainant. From the present complainant, he has cheated 3 lakh. From another complainant, he has cheated 2,20,000. And from another complainant, my lord, he has cheated almost 4 lakh rupees. And my lord, thereafter, the present petitioner has been, my lord, provided this appointment. Kindly see, my lord, it is a forged document. And my lord, the same documents has been, my lord, seized by the police authority from his residence, my lord. Kindly see. And he is the mastermind of the present case. And my lord, all the other accused persons who has been granted bail, not my lord anticipatory bail, they have been arrested as because, and my lord, the present petitioner has been make them as a scapegoat. Not he is the mastermind behind the scam, my lord.
But the complainant has given the money voluntarily, no force was applied upon him.
And in the name of job, my lord. In the name of government job.
Who is the complainant here?
My lord, 21 years, my lord, old girl, my lord.
What is her name?
My lord, Anjali Burman. My lord, there's other two complaints. Another is Babli Burman.
Yes.
Statement of the co-accused.
Another FIR also lodged.
Another FIR is also lodged, my lord. My lord, they are not another FIR is lodged, my lord. They have been tagged together, my lord.
Deepak, he has been granted bail.
Other co-accused has been granted bail, Lordship, but
They have been arrested and my lord subsequently granted bail.
Right. Any statement of Anjali Burman has been recorded?
there is 164 page number, 169.
Any amount has been transferred to the account?
Yes, my lord. I have the WhatsApp chats, my lord. Kindly see where it is found, my lord. Several, my lord.
My lord, since the
Online transaction has
pending in this case, the charge sheet is yet to be filed, so they have not collected the amount of transfer level.
Several amounts has been transferred to the. And my lord, this WhatsApp number is belongs to the present petitioner, my lord.
The complainant being a major lady, by knowing the all consequences, she
Ashwin.
delivered the amount without any force.
Learned advocate for the petitioner submits that the petitioner sorry, the complainant was never coerced by the petitioner to part with the money. The complainant of her own accord has transferred the amount in favor of the petitioner. The co-accused have been granted bail. She seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for bail, and an advocate for the state submits that on the false pretext of providing job in the government offices, the petitioner has taken money from the complainant. The investigation is under progress. The allegations are squarely against this petitioner. Seeks for dismissal of the prayer for grant of anticipatory bail of the petitioner. Then an advocate for the de facto complainant submits that the petitioner is the kingpin of in duping the complainant and others in the garb of providing job in the government offices. He seeks for dismissal. He also seeks for dismissal. Here is the case diary, the materials on record. It is found from the statement of the witnesses that there are serious allegations against this petitioner of taking money from different persons, including the complainant, in the garb of providing jobs. In view of the above and bearing in mind the nature and gravity of the offense, rejected.
Extremely good.
এটা থাকবে।
My lord. We have mentioned that steel management, steel application, but the department mentioned it's not. I think for this, for the moment, this matter is appearing in the list at, I think number 160 matter. It's a wish admin state matter, stay application, stay is necessary in this matter, can it be updated, so that it can be taken up tomorrow, 160 matter.
What is the case? What is the case? Why the state is trying?
Yes, madam. In an NDPS case, Special Court Darjeeling has charged two NDPS accused persons for it. Charged with NDPS cases in a genuine case one. The state will be landing up its own. Next day is fixed for the framing of charge one. So unless this stay application is moved, state will be landing up in suit. This is the urgency.
When did you file
It can be taken up tomorrow during the second half.
Not second of. এটা না?
Yes.
Day after tomorrow, Wednesday, উপরের দিকে রাখো। First item criminal motion. Who is it? The notice has been served?
Well, it is in the motion.
Okay. Day after tomorrow.
Yeah.
Tell you.
I hear also, I also on my lord, up to arrest orders is there.
Second time হবে তো।
My lord, can you say, but hereby it was upon my wife. And we have that this. When you was continue, I am very
Goodbye.
I've been
Then on Wednesday.
Oh, no,
On Wednesday.
yeah,
That-
I don't say,
Because that matter is also there. The similar issue is there
So both the matters.
on Wednesday. In 19টাকে Wednesday তে রেখেছি না?
yeah,
See.
yes.
Yes.
I don't have.
গন্ডগোল কর।
13 নম্বর করছিল নাকি?
স্টেট আছে আজকে আছে সেইটি গেল কোথায়? দেখো তারপর
আচ্ছা, ওটা না আমাদের মেল এসেছিল, হ্যাঁ, দুটোই একই কথা। 14 নম্বর মেলে পাঠিয়েছে, আমরা প্রিন্ট।
next.
লেখা
Oh, you're 20.
I've got a petition.
I'm for the state of Lordship.
Kindly see the Indian Company, your lordship.
What are the sections?
Section, what coming section?
306, I will see.
306, fine.
108 BN.
The daughter of the victim was not the complaint on 12 June 2025. And the incident occurred on 12 June 2025, but before was born 25 June of 2028, that is after court, the FIR clause. And daughter of the victim was stated that one woman named Lachu Padai, who is the neighbor of the deceased. And he took the victim for a job at Moinagu before prior to commit suicide. But unfortunately, the name of the Lachibara was not registered in the FIR. Register was also a FIR name of this person, that is on you, that is the present petition. Just only the present petitioner, not the relative, not the near relation of the victim. Only for allegation is that prior to commit suicide, a telephonic conversation was held in between the victim and present petitioner. This is the allegation, and also allegation is that before prior committing the suicide, the present petitioner asking her to come back to work. Just only for this man was mentioned in this case. And your petitioner had no role about the committing suicide, about the allegation. They are not physically meet with the present victim. Just only for
Yes.
what telephone conversation was held. Investigation must progress, your lordship.
But prior to the commission of offense, there was a CDR, conversion between the present petitioner and the deceased lady, That is why I am. The CDR is very clear that prior to the death, there was a conversion
Abetment of
several times, but after the death, that present petitioner again called her, but that was received by her daughter, that is the de facto complaint.
the abetment of.
And after having knowledge that she has already died, committing suicide, then he stopped the telephonic conversation.
It is crystal clear from the FIR that one.
What is the statement? Statement.
Yes, my lord. Statement, daughter, that is the de facto complaint, page 3, and neighbor, page 8 to 10.
That one lady, your lordship, the.
Page 3, 8 and 10, my lord.
Took the victim at Moina.
Charge sheet pending, my lord. This is the initial stage of investigation.
The case was registered in the month of June, your lordship. Investigation must progress. And over there was the abatement of the abatement, nothing attacked. Just only for telephonic conversation was held before committing suicide. This is the allegation.
Abatement of
There is
charge is
abatement,
there. Well
abatement,
established.
nothing attacked.
Charge sheet is pending, my lord. At this stage, the state
Investigation
have
must progress. The case was registered before 6 months ago.
criminal object the prayer of bail petition.
Only for what telephone conversation, not the abatement, not attack the abatement in this case. Only for what telephone conversation was held in between the victim and the present. This is the allegation.
Completed?
Initial stage of ignition, my lord.
Wait, wait,
Still here is there.
wait. When did she commit suicide? When did she commit suicide? PM report?
Page 47. Page 47.
The advocate for the petitioner submits that there are no direct allegations against the petitioner.
On the 12 June 2025.
Save and accept that the petitioner tried to contact the mother of the complainant. He seeks for, the petitioner renews his prayer for bail. Opposing such prayer for, renews his prayer for anticipatory bail. Opposing such prayer for anticipatory bail, an advocate for state submits that the victim was put into some illegal activities by two accused persons are there?
Yes.
By two accused persons, including this petitioner, which prompted her to commit suicide. PM report at page?
PM report page, my lord, 47.
He seeks for
Belonging anti-mortem injury.
dismissal of the and prayer for anticipatory bail. Peruse the case and materials from record. The statement of the witnesses shows that there are allegations against this petitioner with along with one other of irregularity. Or engaging the deceased victim in some illegal activities. The call detail reports CDR. Call detail reports bracket is CDR. Wherefrom it appears that this petitioner called the victim. In view of the PM report shows that the death was due to effects of hanging. Roll page number 2, which is antemortem in nature. Effects of asphyxia as a result of hanging, which is antemortem in nature. Asphyxia. Effects of asphyxia as a result of hanging, which is antemortem in nature. The investigation is under progress. Considering the nature of allegation and the materials as indicated above, rejected.
I'm grateful, Your Lordship.
$21.
So I'm for the petitioner.
And for the petitioner.
I'm for the state lordship.
With the allegations are under section 465, 468, 471, I guess. But allegation is that petitioner submitted a break birth certificate for obtaining a voter ID card. Thereafter, video has been lost with experiment. But however, the petitioner is a villager and he is unaware of the process of obtaining voter ID card. But he approached a local person who claimed to assist villagers in procurating genuine certificates.
Yes.
Lordship, earlier occasion, Lordship, it's 22nd July 25, it was rejected, Lordship. Page 8 of this application, Lordship. Thereafter, no change in circumstances, Lordship. Charge sheet pending, before charge sheet it is rejected, now charge sheet pending.
Now, the advocate for the petitioner submits that the petitioner is a layman. And as such, for voters card, issuance of voters card, for
Yes, sir.
issuance of
Enlisted
voters
after
card,
voter.
he produced certain documents. There is no criminality in the act of the petitioner. The petitioner renews his prayer for anticipatory bail. Learned advocate for the state
Yes,
is
Lordship. This is the report,
submits that
the birth certificate was fake and
in
false.
considering all aspects, this court in CRM A 542 of 2025 has dismissed the prayer, has rejected the prayer of the petitioner for anticipatory bail. He seeks for dismissal of the application for anticipatory bail. Here is the case diary, the materials on record. This court in CRM A 542 of 2025 has rejected the prayer of the petitioner for anticipatory bail after considering the entire circumstances. There is no change in circumstances. Accordingly, the application being CRM A 755 of 2020 stands. The rejected application stands dismissed.
Grateful, Lordship.
$22.
I'm for the state. I'm for the petitioner at number 22, Lord.
And I am for the de facto complaint.
Allegation against me is under section 318, 351 and 61 to the PNS, my lord. Alleged, my lord,
61 is
61 is for conspiracy, my lord. Cheating, criminal intimidation and conspiracy, my lord. Allegation is that, my lord, allegedly, I promised to sell my flat. I took money and neither I gave registry nor the possession. So subsequently, when I returned the money through check, that was dishonored, my lord. This is the allegation, my lord, against me. Kindly come to page number 10 of my application, my lord. At 15th line, my lord. This is the complaint. I am reading it out, my lord. It has been clearly mentioned that on 18/8/2023, at the left
Where?
side, page number 10, left side, post dated check dated 18/8/2023. So in the year 2023, these checks were dishonored, my lord. Though in the complaint, the date of dishonor has not been mentioned, but prima facie it can be stated that within the 3 months of the issuance of those checks, those were dishonored. This is the first thing, my lord, and it has been clearly mentioned those checks were post-dated checks, my lord. And this FIR was instituted in the year 2025. And there is no such explanation in the complaint why this 2 years delay was taken place. This is the first thing, my lord. Secondly, my lord, kindly come to page number 12, annexure P2 of my application. Here, my lord, firstly, there was stated that they took post-dated checks from me. On 9th December 2022, I issued a complaint before the jurisdictional police officer with allegation that they are pressurizing me and they're threatening me to obtain money from me, my lord. My complaint was first one, that is previous complaint was done by me, and as a counterblast, when they have taken check from me, those were dishonored. And all this took place due to the promised sale of flat, my lord. And thirdly, my lord, day before yesterday, I got a summons from the learned civil judge senior division Jalpaiguri, whereby, my lord, this de facto complainant has issued a civil suit against, that is the money suit against me. So, my lord, there is case and counter case, there is delay of 2 years of lodging FIR, and there is a civil dispute for which civil suit is pending, my lord. Therefore, my lord, I am praying anticipatory bail on any condition, my lord. And last thing, my lord, the allegation is mainly based is against of the lady, namely Kanchan Chetri, because she has issued the check. That's why the money suit has instituted against Kanchan Chetri. However, this BK Jaiswal neither issued any check, nothing, but he has been added in this criminal case, my lord. So I'm praying for bail for both the persons, my lord.
oh, both mean Vicky is the agreement. He has entered into agreement.
Yes, Vicky. Vicky is the husband of Kanchan Chetri. Kanchan Chetri issued those checks, and that too in the year 2023. And
with,
after 2 years,
with whom the complainant entered into agreement for sale? With which person the complainant entered into agreement for sale?
Allegedly, this agreement was with Ashish Malakar. This is the de facto.
Of these two petitioners, with whom the de facto complainant entered into agreement?
With Kanchan Chetri, my lord.
Kanchan,
Kanchan Chetri.
you have a copy of the agreement?
Yes, my lord. No copy.
There are 3 agreements, my lord. First is of August 2022. Next is of my lord 15th December 22 and 19th April 23. My lord, these are there. Unfortunately, my lord, the first one has been put on the top. I flagged it for your lordship's kind consideration. The last one, my lord, the last flag is the first one. Kindly seize the first one, my lord, where we had entered into an agreement.
What is the total consideration?
24,50,000, my lord, was the consideration. I have paid 22 lakhs, which has been acknowledged in the last agreement, my lord. Now, I was approached, my lord, by one Mr. Mahato, who is a relative of Kanchan Chetri and Biki Jaiswal, saying that they are in deep financial trouble. So I wanted that flat, my lord. I paid that money on the assurance that Kanchan Chetri will repay that amount to the bank and as well as to the promoter. Now, she did not do that. Now, as a result, what has happened, my lord? I am not able to get possession of my flat. Neither the registration has been given to me by the bank or by the promoter because all their money are unpaid. Whenever I tried to contact them, they said, I will give, I will give. There was also one sitting with some elders of the locality, she said giving. After that, what happened, my lord? Whenever I tried to contact them, their phone is switched off, their house is locked. I went there and inquired, my lord. What I was told that they have gone to Nepal. Now they are in Nepal, my lord. And I do not have a copy because it is not incumbent upon them to serve upon me. But I've seen it from my learned friend's petition, my lord. Some constituted attorney has signed it. None of the petitioners are there before your lordship because they are in Nepal, my lord.
My lord,
So having said that, my lord, there might be a civil side of it, but the criminality of the petitioners before your lordship cannot be taken away, my lord.
After 2 years.
Somebody, my lord,
FIR
and there is no limitation in filing an FIR, my lord knows that.
But after 2 years, my lord, it's too long to.
There's no limitation, my lord. I can.
And already they have filed one civil suit, my lord.
And my lord, I do not know who is, my lord, who is this person who has affirmed this petition on the basis of what document has it been petitioned. There is nothing, my lord.
Join investigation.
Grateful, my lord.
The
No order right now.
pending is there, my lord.
Join the investigation.
Grateful, my lord.
And no notice was served upon me.
In the meantime, no
from the
coercive
investigating
steps be taken. You join the investigation.
Could not have been possibly, my lord. They are absconding, my lord. They are in Nepal.
Till then, they should.
Ashun, then advocate for the petitioner.
But till then, they should
Submit that.
upon me, my lord.
Submit
So
that.
I can appear before the police, my lord.
You know. Submit that. An agreement for sale was entered between the parties. Between the petitioner and the complainant. Agreement sale बोला ना of a flat करो.
The first agreement
At a
is
total consideration price of 24,50,000. Possession has been delivered.
No, my lord, because they have not paid the bank, neither the promoter. So I am not getting possession. And they are absconding.
Total amount paid
22 lakhs, my lord. It will reflect from the last agreement dated 19th of April 2023, the first agreement before your lordship, my lord, which says
the
internal page 3, second paragraph, my lord. My lord is there. And whereas the first party and second party here of executed agreement for sale of 2 BHK flat together with 1 car parking space on 38/2022 in terms of conditions mentioned therein, and accordingly on the basis of the said agreement, paid 22 lakhs.
issued checks the complainant for repayment of the amount received. Those have been dishonored. The complainant has filed a civil suit for recovery of the money. The entire dispute is civil in nature. Learned advocate for the state submits that though the monetary transactions arise out of contractual obligation. However, the petitioners have not cooperated in investigation till date. The advocate for the de facto complainant submits that 22 lakhs out of 24 lakh 50,000 have already been paid to the petitioners. But the neither registration nor possession of the flat has been handed over. Flat in question has been handed over. And the petitioners are absconding. Considering the totality of the circumstances, the petitioners are directed to join investigation and cooperate with the investigating agency. In the meantime, there should not be any coercive action. List this matter on Thursday. On Thursday. Join investigation. On Thursday, file a report.
Gratefully. Till then, we'll not to arrest me.
No coercive action will be taken. You join the investigation. They say that you are in Kathmandu.
I shall join. Yeah, I shall join.
On Thursday, the matter will be taken up.
Grateful. Obviously.
The state is directed to file a report.
I think 23.
For short parts of it, conducting advocacy report number 4 on the
देखिए कैसे? Council. Who is for the state in this item?
Mr. Luksam is there.
Sorry.
Please for time. You have the case diary?
Yes, ma'am.
Rita Devi. Yes. Who will conduct the case? चलो 5 मिनट में
Item 24.
Time for the state.
item 24, Vibhashan Bhattacharya from principal bench is about to appear virtually, but usually they will be put in, should kindly fix the date on Thursday.
On the prayer of learned advocate for the petitioner. This matter first.
Defective. Defective.
My lord, the main accused persons are already on bail, and charge sheet has already been filed in this case, and I am the father-in-law in this matter and the FIR which was lost initially.
What are the sections?
Was under general allegation of 498A and 304B of the previous Indian Penal Code, which is corresponding to section 85 and 82. And as well as murder 302. Subsequently, the case has been improvised based on the 164 statement of the parent of the victim. The case was improvised to that father-in-law used to rape her daughter-in-law, his daughter-in-law. That is the allegation. But in FIR, there is no hints about that, and although the FIR was lost after 2 days of the alleged incident.
Yes, madam, I'm holding the 164, giving the 164 statement, Lordship. I am the de facto common lordship, and the main allegation against this accused petitioner. And the learned session judge pleased to reject the anticipatory bail on that ground. No, in respect of this appeal. In respect of this accused petitioner.
Other accused have been granted anticipatory bail?
Yes, no. One of the granted.
Mother.
Another, the husband was arrested by the under section 439. 439. And other two accused, the mother-in-law and brother-in-law. They surrendered and bail was regular bail was granted.
Date that occurred, when was the marriage? When did the marriage take place?
In FIR, there is no specific date. 1 year ago, it is written.
1 year ago, that has been within 1 year. Within 1 year.
Within 1 year.
Within 1 year.
So actually, the family member of the victim was always against this marriage, and when the victim attained pregnancy, at that time he used to remain depressed, and the family members even at that time refused to accept their marriage, and that is what leads to this group and affectful incidents. But taking mentions, they are asking such a weird allegation against the dowry date as well as murder has been under the same reason.
Either you finish your submissions or let me go through the records. If you have not completed, make your submissions, thereafter we'll go through the records. Make your submissions, complete it, and then I will go through.
The statement was recorded, the 162 statement was recorded after 17 days of the FIR.
Any other? Postmortem report? Any FSL report has been received in respect of the fetus?
No, my lord, but my lord, in the postmortem report, kindly sees, my lord, point 10, that is a bladder. There was a fetus, my lord, she was 5 months pregnant at the time of the incident.
Now, this
Yes,
fetus,
madam.
what happened to the fetus? It has been sent to the FSL for further.
Yes, but my lord, report is yet to be received, but she was pregnant and the point 10, the bladder, it reflects that she was pregnant.
Then the advocate for the petitioner submits that he is the father-in-law of the deceased. There are no such direct allegations against the petitioner. The husband and other co-accused have been granted bail. He seeks for grant of anticipatory bail in favor of the the there is improvement in the case of the prosecution so far as the allegations as revealed in the 164 statement in the statement of the witness recorded under section 164 CRPC. He seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, learned advocate for the state submits that there are specific allegations against this petitioner who happens to be the father-in-law of causing rape upon the victim. The victim PM report of victim died within 1 year of her marriage. He seeks for dismissal of the application for anticipatory bail. Similar submission is advanced on behalf of the de facto complainant. Here is the case diary materials on record. Upon going through the statement of the witness recorded under section 164 of the CRPC, it is found that there are specific allegations against this petitioner of causing rape upon the victim. Considering such materials and the nature and gravity of the PM report
Yes, page 49.
49.
40.
The PM report records that the date was due to effectual hanging, which is antemortem in nature. The victim at the time of the incident was pregnant. 15/17 weeks. Considering that rejected.
Thank you. 26. Mr. Bharat Taylor appeared on her.
26 কে করছে? পিটিশনারের নাম কি?
হ্যাঁ, দয়াল রয়, এটাই আছে।
আর কি করবো? বহুত বড় গাড়ি। তুই ভাব, রিজেক্ট করো।
ট্রাই করে রেজেক্ট করা আছে।
অল্প অপারেশন বাবা। কি বলছে যে
Yes. দেখো সাউন্ডটা শোনা যাচ্ছে। মিউট করেছো না কি হয়েছে? কথা শোনা যাচ্ছে না?
দেখি দয়াল রায়ের অনেক মনে হয় দুজনই
Can you hear me?
দেখি দুজন পিটিশনারই এসেছে দয়াল রায়ের অনেক।
ওকে বলো একটা মেসেজ করে দাও।
কেটে কেটে ওনাকে আউট করে দিন না, উনি আবার জয়েন করে যাবো।
You disconnect yourself and rejoin. No, you can hear me.
দেখলেই তো সাথে মারছে দেখ এই যে
ট্যাবলেটটা একটু দিন না।
সে
My lord, I am in item number 26. Am I audible to your lordship?
Yes,
Am I audible to your lordship?
yes.
My lord, this is the second application for anticipatory bail. The first one was dismissed for default.
Okay.
Subsequently, the petitioner filed a case for, subsequently the petitioner filed an application, my lord, which was rejected, but there was an observation of the court that the petitioner can file a fresh application. My sister colleague will hand over that order, my lord.
দেখো তো আরেকটা কোনো অ্যাপ্লিকেশন আছে? Is there any other application filed by any other co-accused in the case?
My lord, to my knowledge, it was in item number 23, but that was not from my side.
23 টা বার করো। 23 টা বার করো।
বলে দে, এনার লোকের শেয়ারিং হয়ে যাবো।
কে আছে দেখি তো? 23 টা কে আছে? ওটাই পিটিশনারটা কে? রীতা দেবী। রীতা দেবী প্রসাদ সোনার নট প্রেস।
26 দিচ্ছি।
Who is in 23?
And what statement?
And in 26, who is for the state?
Yes.
26 I am applying for the state.
23.
26.
No.
Oh,
let us
26.
have-
Yes.
23.
Gist of the allegation is that a gift deed was made in favor of this petition by her husband. And the de facto complainant is the sister of the husband. He made that gift deed by depriving the other legal aid. This is the allegation. In the
No, de facto complainant is the sister of the petitioner.
Yes, Lord. And as per the FIR, in the FIR, I was not made an accused. Thereafter, after lodging the FIR, the husband of this petitioner and the son of this petitioner were arrested. And during the custody, it has been alleged that during the custody, the son has stated that the deed is in my custody. On such allegation, I am implicated in this case. Lordship, this is totally false. I have no knowledge about the deed, Lordship. And
Who executed the deed of gift?
Lordship, the deed was made by my husband, it is admitted, Lordship, but being an old infirm lady, I have no knowledge about the deed. I am willing to cooperate with the investigation in any manner, Lordship, in finding
This
the
deed of gift was executed in favor of the de facto complainant.
Lordship, the deed was in favor of me.
Okay.
It was gifted. Gifted.
Okay.
But now, where the deed is kept in line, I have no knowledge regarding
If
it.
the deed of gift is in your favor, then incidentally the custody of that document will be with you. So where is the criminal offense?
Of the, and I was made an accused in the FIR also, Lordship. Kindly granting bail, Lordship, being an old lady, it's very
Okay.
please behind the bar.
No, what happened, my lord,
Hmm.
in this particular case, one Hiralal Prasad was the owner of 17 Chhataka plan. And Hiralal, subsequently Hiralal Prasad died leaving his 8 legal.
Hiralal Prasad.
Yes. What happened, my lord? The present petitioner, that is the Rita Devi, his husband, her husband, Nandalal, Rabindranath Roy, did write one deed writer, and another accused, they procured Hiralal's legal heir certificate. Though the Hiralal leaving 8 legal heir certificate, they hurriedly obtained a fake legal heir certificate showing 4 legal heirs.
So this person,
Instead of 8 legal heirs.
Rita,
And my lord,
Rita Devi is the wife of Hiralal.
yes, madam.
Oh.
Hiralal is the kingpin. He arranged all these things. And Nandalal. What and interesting thing is, my lord, the memo number of legal heir certificate which was issued by the Pradhan showing another memo number that was issued in another person in a residential certificate. That memo was issued. And that report is very clear. The statement of report of Gram Panchayat as well as the Pradhan. Yes, this is the memo number, but it was issued in residence certificate that another Papu, something like that. And on the strength of that legal heir certificate, they illegally transferred the said land of Hiralal by way of gift in the name of Rita Devi. One detective was there. He one of the accused, FNM accused.
Sure.
If your lordship kindly see the report of Pradhan, that is page 89.
Who executed the deed of gift? The rest 3 legal heirs executed deed of gift in favor of the mother.
Yes, 4 legal. Out of 8.
Rita Devi and 3 of her sons or daughters, whatever, have forged a document stating that these are the 4 legal heirs.
Yes, Mr.
Out of the 4, 3 have executed deed of gift in favor of Rita Devi.
Out of 8, they obtained 1 legal heir certificate.
Forget about that. The deed of gift has been executed by whom in favor of Rita Devi?
4 legal heirs of Hiralal Prasad.
Rita Devi. Madam, let me understand. Rita Devi is not the legal heir of Hiralal.
No.
A separate person.
Rita Devi is a wife of Nandalal, the principal accused.
Okay. So they are not Nandalal and Rita Devi are not the legal heirs of Hiralal.
Oh.
Okay.
They obtained fraudulently obtained the 17 Chhattak land of Hiralal.
Gotcha.
But Hiralal having 8 legal heirs. But they hurriedly or fraudulently managed the legal heir certificate of 4 person. And who is the 4 person? We don't know. But deed was executed.
This is,
showing the same.
this is the original legal year certificate. This is the original one. Showing eight persons.
At page 90.
Hmm.
Page 19 below. This is the original legal heir certificate of, this is Hirana, who was the owner of 17 Chotak of land.
And which one is forged one?
Yes, my lord, at page
Page number.
25 and 26.
CD to Bhumij.
Yes, yes. This is the original CD, my lord. Same page, my
Where
lord.
they're showing 4.
26, my lord. Page 26 in the original.
Where's the deed of gift?
Deed of gift, my lord. Sell it, sold it, sell it. Page 33, my lord. Sell it.
33.
Sell it or gift
No,
it?
gift it. That fake.
Sell it na, gift it.
দানপত্র।
Yes, my lord. এই 26-এরটাও নিয়ে নিন।
That is what I'm saying.
Yes.
A forged legal year certificate has been procured by 4 of the accused persons.
Yes.
Claiming themselves to be the legal heir of Hiralal.
Yes.
Correct?
Yes.
Out of these 4, 3 executed gift deed in favor of wife of one of the accused,
Yes.
that is Nandolal.
Yes.
So Nandolal is a legal heir of Hiralal.
Yes.
Yeah.
Correct?
Yes.
Yes.
So Rita Devi is the wife of Nandolal.
Yes. This is the fact.
Yes.
Rita Devi and Nandolal is the principal accused, so he is already elaborating bail.
This petitioner is the wife.
But now I have come to know that these are recovered.
Who made the application before the authority for getting the legal year certificate?
The Nandolal and Malad.
Or not at all, there is any application?
There is no
Or the-
application is not seized in the case diary. Application not seized. Directly the forged one.
And what is the statement of this Pradhan?
Pradhan, my lord, at page 89 and 120. Report. Yeah, official report.
But I am on behalf of the Pradhan in 26.
And statement is page 83. No?
83.
Satyendra Rai,
83.
Gram Panchayat. Stop.
Statement record हो गया।
ईशा नाम जानोगी तुम्हारे का नाम जानोगी रीता देवी रीता देवी নন্দন বাবা তো ইসে ওনা আরে ওর ভাই বোনকে স্কুল করে ও একা একা হয় নিজের নিজের বোন জায়গায় সারিস কোন আমার তো বুঝলাম অর্ডিন্যান্স দিয়ে দিলাম হ্যাঁ দিতে
And what is the complicity of this petitioner Rita Devi? Accepting that a deed has been executed.
He accepted the said gift,
Okay.
knowing fully well that that was.
She was present in at the time of registration.
And obviously she was present at the time of registration of that particular gift deed below. She has every knowledge.
But there is no allegation that I am forging for the documents, Lordship. Only
Okay.
it was in my custody, which is already recovered.
She accepted the claim.
I am willing to
She is one of the member of
confirm this conviction, Lordship.
Fine.
Principal is accused.
Crime gang.
34 is there, 34 is there. 34 আছে তো
34 থাক
34 is there, my lord.
You are for?
Well, in item number 26, let me address the court on the petitioner number 2 first. Petitioner number 2 happens to be the Pradhan of the Panchayat. Now, my lord, she was served a notice under section 35(3) on the 9th of November. We made a legal notice to the investigating officer that she is not able to attend for reason being that she is 33 weeks pregnant. My sister colleague will hand over that notice, my lord.
And why you have filed an application under 438?
My lord, my apprehension of arrest is they've served
Only
me a
why is
notice.
accused?
Yes, my lord.
Pradhan is also an accused.
My lord, I am not the FIR named accused. They have served me a notice under section 35(3). I am 33 weeks pregnant. I have made a notice to them that I am pregnant, and the only reason they are calling me for investigation is for recording the specimen signature. They have served me the 35(3) notice. I made a reply. My sister colleague will hand over that reply.
Okay.
And the petitioner number 1, he happens to be the husband of the Pradhan. That is the petitioner number 2. That is the only thing he's been made an accused in this case. No notice has been served to petitioner number 1. Considering the pregnancy in the advanced stage of pregnancy, she is
Husband
9
is
months
also an
pregnant.
accused. Husband is also an accused, my lord. More surprisingly, my lord, kindly see the memo of evidence of the original case diary, my lord. Kindly see. There are several similar type of cases pending before several courts, my lord. Kindly see the memorandum of evidence, my lord, last page. There are, yes, last page, there are several number of similar type of cases. At the top, my lord, at the top. Doyal Bhai, the husband of the Pradhan.
Legal hair, and accordingly we issue the
Previous antecedents are there, my lord. Being the husband of the Pradhan, he has committed this type of several offences.
May I please, my lord?
Ashut.
May I please, my lord?
Yes, yes.
I have a short submission, my lord. My lord, kindly takes page number 17 of my application.
Statements against Doyal.
My lord, statement against Doyal, my lord. 83 as 83, page 83, 87.
All are staff of Gram Panchayat.
আর exercise হতো। পেজ কোথায় আছে? 760. পুষ্কর দাস। ছাব্বিশটা হচ্ছে শিলাগাড়িলাট।
Okay, email लेता है first. अब पैनिक भी नहीं करिए अपना.
Seventeen Pro Max. 17 Pro Max.
May I please, my lord?
Yes.
Lord, kindly takes page number 17 and 18 of my application.
Oh.
Oh.
My lord, these are the medical reports of the petitioner number 2. She is 9 months pregnant as on date. And my lord, when I come to petitioner number 1, my lord, all the sections are triable by the court of magistrate where the punishment is less than 7 years. My lord, our Honorable High Court had passed a notification in the year 2023, my lord, pursuant to the judgment of the Honorable Supreme Court. My sister colleague will hand over that notification. My lord, the last paragraph of that notification. It is mandatory for the investigating officer.
Yes.
My lord, Dayal was never served a notice. Petitioner number 2 was served a notice. We made a reply, and they want me for the investigation just to record the specimen signature. And I am 9 months pregnant, my lord. Kindly considers.
753.
At my residence also holding.
My signature can be obtained at my residence too, my lord. Kindly consider on humanitarian ground.
ठीक है ना এখন ফোন করে যেতে হবে
Dismiss for default, previous antecedent.
মর্নিং এ ফার্স্ট করে ফর অর্ডার সেটা রেখে দাও তো কালকে রাস এটা ফর অর্ডার সেই জন্য কালকে রেখে দিন কালকে ফর অর্ডার সেই জন্য produce the case diary tomorrow because there is a full court reference in that event.
My lord, there is one certified copy of the case diary is there, my lord. My lord,
Can
can
you produce this tomorrow?
Yes, my lord.
I have heard you. For orders, it উপরের দিকে for orders.
Grateful, grateful.
I'm ready.
Number 172.
সেটা আমাকে একটু দেবো, হ্যাঁ, হ্যাঁ, আমাদের
In that case, you have to because you know the court would not allow the man. We'll stay back. In that case, can you pick it up tomorrow? Because the contested application could not be taken up. It is highly unlikely tomorrow. Item number 172.
What is the urgency? 172. What is the urgency? He has mentioned in the morning.
He had mentioned the other matter.
No mention right now.
item number 145.
Chalo.
145.
All matters. No. Thank you.